There's going to be irreparable harm for Gwen. We're allowed to fire Gwen. Not our problem that she was a terrible steward of the government power and we don't want her in government anymore. Get out. It's not irreparable harm. Go get a job, whether you like it or not. You just elected a president. He doesn't want her in the administration anymore. That's tough luck because this is democracy and you're going to take our people whether you like it or not. The March 4th order of the U.S. District Court in D.C. are hereby, listen up, Beryl, stayed pending the disposition of this appeal in Circuit Court in D.C. Another corrupt D.C. judge reversed, this time from the Supreme Court in a 6-3 decision along party lines. It's in the case of Gwen Wilcox versus Trump and has gone up to the Supreme Court after it came out of this judge's courtroom. Beryl Howell. You remember her from the J6 cases, from the Trump investigations, impeachment. She was a part of breaching Trump's attorney-client privilege with his attorneys and Evan Corcoran and all of them. Monstrous judge. She was appointed by Obama back in 2010, oversaw a bunch of grand juries that pierced into Trump's affairs, and has been very pro-prosecution in the J6 cases. Well, what happened was, in this case, Wilcox versus Trump, you can see that they sued Trump and they said, Gwen Wilcox came out and said, you can't fire me. Who do you think you are, the president of the United States? Saying, I'm in charge of an independent agency and Congress created us and they can do whatever we want. No, not how it works. So they sued after they got fired. Here is the order from the terrible judge called Howell, which just got obliterated and reversed. What a loser. Here's what she wrote before she got reversed badly. It says here, the judge writing, yesterday evening on Friday, Trump and other people filed a motion to stay this court's judgment, right? Because she basically said, hire these people back. You can't do what you did, blah, blah, blah. Wilcox's motion for summary judgment, Trump DOJ is fighting her and she's saying, okay, I just got all your paperwork. Now, this court declared, and Trump even conceded, that the president's termination of the plaintiff was unlawful and therefore it's null and void. And I'm really doubting they conceded that, right? Now, in addition, this court ordered the Wilcox people who were just fired to remain on the board and said that you cannot, said this to Trump, you cannot in any way treat them as having been removed from office because you're like not the president. I am. I'm Beryl Howell. I run things here. From impeding in any way her ability to fulfill her duties on this board or from denying her or obstructing her authority, right? Trump wanted all of that stayed and stopped. And she says, okay, I'll think about it. Says, including you can't give her the necessary access to the facilities. She has to be able to carry out her duties and blah, blah, blah. Now, she, Wilcox, Gwen, who's a public servant, who is now opposing this motion for a stay from Trump. And for all these reasons, Judge Beryl, before she just got reversed here and got the proverbial Supreme Court legal backhand, she says, we ask whether a stay is appropriate based on 4 factors. Writing, 1, whether the stay, whether they're going to win on the merits, whether there's going to be an irreparable injury, substantial injury, and wherever the public interest lies, right? The same injunction standards that we've talked about a lot. And basically the judges use this provision to shoehorn in policy changes. They say, oh yeah, there's going to be irreparable harm for Gwen. We're allowed to fire Gwen. Not our problem that she was a terrible steward of the government power and we don't want her in government anymore. Get out. It's not irreparable harm. Go get a job. But they use this to say, well, it's going to be damaging. And since they have sympathies with the person who's going to be damaged, then they can do whatever they want under the rules. And they have a justification and a literal framework to do it. She says, for all of the reasons explained, Trump has not made the showing that they're going to win. Ooh, yeah, I think they will because the Supreme Court just reversed you, Beryl. Trump has conceded that the president violated the law, right? So the Trump administration, these judges are nuts, has conceded that he violated the law when he removed her from a presidentially appointed Senate-confirmed position and a member of the NLRB, the National Labor Relations Board, without complying with the statutory procedural for-cause requirements for removal. And they set these boards up and they say, well, you can't remove anything because Congress said so. And Congress created these rules that are for-cause bases for actually removing somebody from that position. But what's interesting about this is, okay, is Congress in charge or is the executive branch in charge? Oh, it's a commingling of the two? Oh, it's an independent agency? So what branch of government does it reside under? Oh, it doesn't reside under any of them. Oh, so it's unconstitutional then, right? Otherwise, it has to reside under the executive branch because they execute the law under the Constitution, clearly. So the judge is just like writing stuff that she's just making up out of her tish. And their constitutional challenge is foreclosed by binding precedent, which is Humphrey's executor, which is going to be hilarious. We'll see what the Supreme Court says about that because this case is on the ropes. Remember that the other person, I think Hunter Biden's like law school friend or whatever, remember he was also a fuera out of here. He sued and lost. And he made the same claim under Humphrey's executor, but that didn't work out. So Beryl is now latching on to a bad case where there's precedent where the other people have lost. And that guy actually, I think, canceled his case before it set this bad precedent. He was smart enough. He's like, oh crap, okay, I'll just call it. Because he didn't want the Court of Appeals to come out and issue a ruling that would have been adverse to everybody else. So saying here, Trump's reliance on case law pertaining to offices led by single directors instead of multi-board members with staggered terms, thereby made accountable to to the president through his exercise of appointment power, plus at the NLRB, his at-will removal power, is exemplary of how their argument is unsupported by existing doctrine, citing other cases. Dellinger, that's right, Scott Dellinger, right? So she does actually cite it. And Katzis was talking about it. And I think he dismissed his case, so it wasn't decided on the merits once it went up on appeal, and they issued a stay. Remember, he was like, I dismiss, because he knew it was going to come back badly. To be sure, Trump is intent on urging the Supreme Court to overrule Humphreys, and we'll see if they do that. But that aspiration is just that. And the essence of the rule of law is that this court may not anticipate changes to legal precedent. So even though it looks like it might be changing very soon, it hasn't yet, and so I'm going to follow the old rules. Saying Trump's failure to show that he's going to win, even though he just won, is arguably a fatal flaw for a stay. But Trump also fails to satisfy the other factors. Trump does not describe any harm that they're going to experience, right? So the fact that some other individual called Gwen that Trump does not want in his office is going to be there does not harm him at all. You can just take logic about this in your place of business. If your company wants somebody fired and they're not fired, is that good for you? You have to sit there and work with this person who's terrible. Plaintiff and the public, on the other hand, experience harm every day that she's not able to fulfill her statutory role, and the NLRB is thus unable to function, right? So since it's independent, Trump has no say over it, and she has to do this job. If she doesn't, we're all going to die. Finally, as Gwen notes, contrary to Trump's suggestion, the DC Circuit Court and their grant of an emergency stay, remember in the Dellinger case, that was the Scott Dellinger case, Hunter's BFF or whatever, is not dispositive. And he ran to dismiss his case because they granted the stay in the Court of Appeals. She's of course in the district court. That case involves a rare single head agency, and that's different than the NLRB, and thus it's not directly controlled. And so she's distinguishing it, and she just got reversed, basically. Accordingly, it is hereby ordered, says Judge Beryl Howell, one of the worst judges in American history, ordered that the defendants and the motion to stay is denied. So that was her final word. Trump obviously appealed that, and the Supreme Court said, oh, sorry, Beryl, you're a moron. Here's why. It says the government, Trump, has applied Beryl's terrible decision and applied for a stay of orders from Beryl's crap courtroom, enjoining the president's removal of the NLRB person called Gwen, who's a public servant, who's going to fulfill her statutory duties and serve you, America, whether you like it or not. You just elected a president. He doesn't want her in the administration anymore. That's tough luck, because this is democracy, and you're going to take our people whether you like it or not, says Judge Beryl Howell. And she's a public servant, and don't be mean to her, okay, because she's sacrificing a lot to serve you even though you don't want her to. Saying here, the president is prohibited by statute, which is obviously unconstitutional, from removing these officers except for cause, and no qualifying cause was given. So the judge says Trump's decision is not good enough for her. Supreme Court says, okay, all right, let's see. That's what the law says. They write, now the application for the stay, this is the Supreme Court writing on application for a stay, saying the Chief Justice got this case referred to the court and the request is granted. Because the Constitution vests the executive power in the president and not in independent agencies that can be set up by Congress. Look at Article 2, Section 1, Clause 1. He may remove without cause executive officials who exercise that power on his behalf, subject to narrow exceptions recognized by our precedent. Now, the stay reflects our judgment that the government is likely to show. Are you reading this, Beryl? Put your wine down for 2 seconds, sober up for 5 minutes, and listen. The stay reflects our judgment that the government is likely to show that both the NLRB and the MSPB, the Merit Service Protection Board, some other independent agency that Congress set up, exercise considerable executive power, obviously. But we do not ultimately decide in this posture whether the NLRB or the MSBP falls within the exception. We haven't decided that yet, but we think it probably is not. That question is better left for the resolution after full briefing and argument, so it's a punt, they'll kick it back down. Now, the stay here, meaning that Trump can fire this person, so you're gone, Gwen, pack your crap up and get out. The stay also reflects our judgment that the government faces greater risk of harm from an order allowing a removed officer to continue exercising that power than a wrongfully removed officer faces in being able to perform her duty. It's a bigger harm on the balancing test, if you put the little teeter-totter there, on Trump. Way harmful to America to have some insurrectionist who should be fired, was fired, continuing to act as a mole and a cancerous tumor inside the administration. You gotta go. Said sorry, enough. Now, the purpose of equitable relief is not to determine the rights of the parties, and so the litigation is going to move forward. But the stay is going to happen now, so she can be fired, get out. A stay is appropriate, so Beryl Howell, you lose, to avoid the disruptive effect of the repeated removal and the reinstatement of officers during the pending of this litigation. Now, finally, the respondents called Gwen and Kathy, two public servants who just are so upset with being fired that they're suing, contend arguments in this case necessarily implicate the constitutionality of for cause pause removal protections for the Federal Reserve and other members of the Federal Open Market Committee, which are unconstitutional as well. But they say we disagree. All right, so we haven't gone that far yet. They're like, well, if you're going to hatchet us, then you got to also hatchet the Federal Reserve. They say that's not true. The Federal Reserve is a uniquely structured, quasi-private entity that follows indistinct historical tradition of the first and second banks of the United States, unlike these other made-up entities, which is like, oh gosh, they're going to analogize it to a national bank. The March 4th order of the U.S. District Court in D.C. are hereby, listen up, Beryl, stayed pending the disposition of this appeal in Circuit Court in D.C. And we already know they're unlikely to find in their favor because they also, the D.C. Circuit, granted a stay in the Scott Bessinger case. Should cert be denied, this stay shall terminate automatically, and so the decision tree comes out. Otherwise, we're going to send this down on judgment of the court. So the court is saying, if we don't like what happens down below, we'll hear it. If we like what happens down below, we're not going to hear it, and it can stand. Signed off by the court. 6-3, as you can see. Pack your bags, Gwen and Kathy, and get out. No one wants you here. No going away party for you either. Now, the lunatic liberals on the court, Kagan, Sotomayor, and Jackson, they're all dissenting. Oh no. They say, we are dissenting. They always do that, right? For 90 years. Okay, well, before that, what happened before those 90 years? Before the court made up Humphrey's executors out of their butts in 1935 and said that these independent agencies do have some basis. What about before that, 1935? How we go all the way back to the 1700s and ask about that. But they don't want to ask about that. They just want to say, well, for the last 90 years, we have been exploiting the courts for our own gain. And now that you're undoing this, we're going to throw a hissy fit. Same crap they did with Roe versus Wade and the others. They say this has stood as a precedent of this court. And it's not just any precedent. It undergirds a significant feature of American governance, bipartisan administration and independence from presidential control, right? And they want this. They don't want the three branches of government because there's checks and balances and there's only so much they can do. If you create these independent bodies and you give them unlimited power with very limited oversight, then the grift can just explode, right? You make your money in the madness, in the gray area. The grift is in the gray area. All these independent bodies that can do whatever they want. We've seen it happen and how it's been so terrible for our country. Now, the current president believes that Humphreys should be overruled or confined. It should. And he has chosen to act on that belief. And they say to take the law into his own hands. What? You guys just ruled 6-3. The court just validated everything he said, weirdos. Not since the 1950s or even before has a president without a legitimate reason. He's got great reasons. Tried to remove an officer from a classic independent agency, a multi-member bipartisan commission, blah, blah, blah. This is new. And we've been doing it unconstitutionally for a long time. And so you should allow us to continue to do that. But the president is now discharged, they say, without cause. I mean, he must have some reason in his brain, but he doesn't have to give you like the just cause. Even if the cause is, I don't want that person in here. I want this other person to manage this position. It's his executive branch. Today, the court effectively blesses those deeds. She writes, I would not. Our decision remains good law. Maybe not for long, right? They're probably getting ready to overrule it. And it forecloses both the presidential firings and the court's decisions. And our emergency docket, hilarious. While fit for some things, like illegal aliens, like emergency docket is perfect for illegal aliens and gangbangers, terrorists, like 14 hours or how long did it take them to rule on that one? Emergency docket is not okay if you're the Trump administration and you have your power being usurped from you by people like Kathy and Gwen. We shouldn't be doing this. This is a short fuse. Hilarious. And they're also quoting Amy Coney Barrett. Wild. Amy is digging herself in a hole, okay? Both people are quoting her on both sides. They're like, Amy, you said don't use that emergency docket. Why'd you just do that and scold that judge out of Texas? Amy. So under that decision, this case is easy. The court found the president has no legal right to relief. Beryl Howell's amazing and blah, blah, blah. Except they say for the Federal Reserve, the majority says the Federal Reserve might have an analog to the national bank, but these other agencies don't. And they are very upset about it. So respectfully, I dissent. And so who wrote this one? It was Kagan. Kagan led that one. All right. So 6-3, they lose. Judge Beryl Howell absolutely crushed. She wrote her order saying that they're going to win and that the Supreme Court was not going to find in Trump's favor. That didn't happen. 6-3. Beryl Howell, one of the worst judges in America, reversed and told. Now, the Supreme Court also delivered another nice victory. Remember this case, DOGE versus Crew, Citizen for Responsibility and Ethics in Washington, a Norm Eisen group filled with lawfare Democratic hacks. They were suing and trying to get discovery into DOGE. Remember, they wanted all their case files, all their records, and more. Yesterday on the show, we did a segment on this, reading through the emergency application to the Supreme Court for a stay on this because the judge in this case in DC ordered that discovery to happen. We said, whoa, that's not going to be good because that's peering into the executive branch, into an advisory agency, and they're not allowed to do that. So they lost. last very short order, as you can see, from John Roberts stopping Norm Eisen for now, saying, all right, Trump and D. John Sauer just submitted this yesterday, and it is ordered that the April 15th and May 20th orders ordering this discovery are hereby stayed pending further order of the court. So another blow to Norm Eisen. You can see more details from Reuters saying they lose. The court put on hold Christopher Cooper's orders for DOGE to respond to a watchdog group, crew, Democrat hack group, not watchdog group, crew seeking an array of records. They filed for FOIA. The Supreme Court said no. And of course, we'll keep our eye on that one. So two nice decisions out of SCOTUS today. Beryl Howell loses. Norm Eisen loses. We're going to wait for the Supreme Court to continue with some good decisions, hopefully soon.